Good morning, distinguished participants and colleagues in Brazil and around the world. Greeting from Bangkok. It is my great pleasure and honor to speak at the third National Forum on Alternative to Imprisonments today, and to share with you some experience on the use of non-custodial measures in Thailand with all of you. First of all, I would like to take this opportunity to briefly talk about my institute. The Thailand Institute of Justice, or TIJ, is an organization established by the government of Thailand in 2011 and officially recognized as a member of the UN Crime Prevention and Criminal Justice Program Network Institute in 2016. One of our primary objectives is to promote and support the implementation of the United Nations standards and norms related to the treatment of offenders through research, capacity building, and policy advocacies. We also work on the wider issues such as the rule of law, justice, innovation, and violence against women and children. Ladies and gentlemen, as the world has observed the impact of the COVID-19 pandemic on various aspects, this crisis has undoubtedly posed a great threat to the criminal justice system worldwide. It has drawn attention to the urgent need to alleviate the chronic problems of prison overcrowding. It also challenges us to think deeper about the purpose of imprisonment, who will be imprisoned and why, and consider different ways or more effective way to sanction and rehabilitate people. Long before, I don't know whether you see my slide. Is there someone, if you can show my slide?
Not yet, Professor Kittipong, but I guess that in a minute the slides will be available.
Okay. I have some figures to show you in the slide. Okay, can you go to the slide 2, please? Okay. Long before the COVID-19 outbreak, most prisons around the world were already struggle with the overcrowding problem. In Thailand, before 1996, the prison overcrowding, the number of the population in prison had remained approximately 120,000, but the Get Tough policy on drugs has resulted in a rapid increase of inmates, as you can see in the graph. The expansion of methamphetamine market in Southeast Asia has been significant over the last few decades, with the manufacture and use of synthetic drugs replacing the cultivation of opium and manufacture and use of heroin. The UNODC World Drug Report highlights that methamphetamine market have grown rapidly in Thailand, Myanmar, Laos, PDR. With this situation, several countries in the region continue to implement punitive drug policy as a response. In 2001, I was appointed as the Director General of the Department of Probation at the Ministry of Justice, and my special assignment at that time was to run the first ever drug diversion program to reduce prison overcrowding. At that time, there were approximately 220 inmates in Thai prison, while the available space could handle only 120,000 persons. The vast majority of prisoners, or more than 70% at that time, were incarcerated because of drug-related offense. Considering the manpower of around 10,000 correction officers, the ratio of officer to inmates is approximately 1 to 24, which is beyond a lot below the international standard. In 2002, the parliament passed the Drug Rehabilitation Act, which was considered a major criminal justice reform in Thailand. This law has for the first time introduced compulsory drug treatment programs under the administration of the Department of Probation to the country. This drug diversion program allows drug addicts to undergo treatment instead of prosecuting them. If they are unwilling to receive treatment and keep up their drug habits, the prosecutor will drop the charges. In Thailand, methamphetamine users are often portrayed as crazed homicidal people who are essentially evil and need to be punished. This view was cultivated partially to the drug war during the last decades. In order to ease public sentiments against drug users, the government introduced a slogan called "Drug addicts are patients, not criminals," and drug addicts should undergo treatment, not punishment, while drug dealers and drug traffickers should be severely punished. This campaign is an important step to promote public acceptance of the drug diversion program by boosting their understanding that drug use disorder is a public health issue, not a criminal justice issue. According to the procedure specified by Drug Rehabilitation Act, those arrested under the drug consumption charge will be sent to Department of Probation for assessment and review of the level of their addiction. The department has set up a drug rehabilitation committees in every provinces all over the country to be responsible for that task. Consider of not only criminal justice official, but official for public health as well as local administration. Moreover, the probation department established very important community justice network within certain communities around the country. These networks play a crucial role in the persuasion of drug users and drug addicts to receive treatment in voluntary treatment programs without having to arrest them, and to follow up and support them after the treatment. For several years, that Thailand has implemented drug rehabilitation and promote a campaign on drug treatment. The number of people joining the compulsory drug treatment was increasing, resulting in a significant drop in the prison population during 2003 to 2006. As you can see on the slide, in the middle of the slide, you can see a sharp drop there. However, after 2006, prison population has been on a rise again. The explanation for this upward trend is rather complex and multidimensional. Lack of continuous effort to improve the law, leaving the drug law enforcement to the police, the campaign being discontinued, lack of effective coordination among governmental agencies, and inadequate funding for the rehabilitation centers were among the major reasons hindering the successful diversion of drug users from imprisonment. Next slide, please. Currently, around 289,000 people are imprisoned in Thailand, of which 82% are convicted of drug-related offenses. 82% is a very big number. The portion of drug-related prisoners is now even higher than it was in 2001. Also, the majority of prisoners in Thailand receive a prison sentence between 2 to 5 years, and the recidivism rate is 15% during the first year after release. Going back to the time when Thailand introduced the drug diversion program, Portugal, as you may know, has implemented the decriminalization policy for drug users. Its purpose was to reduce the number of new HIV/AIDS cases from drug injection, as well as new drug users through a harm reduction approach, which minimized the involvement of the police and justice systems. Thus far, this model remains inspirational for successful drug policy reform in Thailand. However, given that Thailand is close to the resources of synthetic drug production, and that methamphetamine is a common illicit drug, any effort to address this problem would have to be tailored to fit the situation of the countries. On a positive move, this year, Thailand is going through another major shift in drug policy. The parliament has recently passed new narcotic code in August. The new law is now awaiting royal endorsement before it becomes effective by the end of the year. The new narcotic code will soon replace over 20 existing drug-related laws, emphasizing prevention, rehabilitation, and less severe punishment. The new drug code introduced more rational concept as presumption of possession for personal use for a small amount of drugs instead of possession for sale, abolishing the mandatory minimum sentences and reducing maximum imprisonment sentence for most cases to 15 years. Under the new law, the compulsory drug rehabilitation for those arrested with drug use under the Department of Probation will be removed, allowing the care to be provided by public health professionals for the drug users. The new law also removed the presumption of possession for trafficking based on prescribed mass of substances, allowing circumstantial details of the case to be considered when deciding the case. This is a significant step toward a harm reduction and less punitive response to drug problems in Thailand, which we have to make sure that the implementation of this new law will be done effectively and sustainably with sufficient resources. Next slide, please. In a wider context, the criminal justice system in Thailand faces problem of case backlogs. As you can see in the flow chart, more than half of the cases arrested by the police will be passed on to the prosecutors and the court. The lack of screening processes, such as diversion programs and other alternative measures during the police and prosecutor levels, have resulted in an influx of criminal cases to the formal justice process. Moreover, there are only 5 forms of criminal penalty listed in the Thai criminal code. That is capital punishment, imprisonment, confinement, fines, and forfeiture of property. Therefore, there is limited non-custodial alternative at the court level. With such shortcoming, new justice initiative as a means to solve this limitation are much needed. During the last few decades, there has been an increasing interest in the use of criminal mediation, criminal diversion, and restorative justice, especially in the context of juvenile justice and in the family courts. Speaking from my personal experience, when the concept of restorative justice was first presented to the public in 2000, it has received considerable interest among practitioners and academics. This is partly due to the fact that restorative justice not only presents new ways of looking at crime and punishment, but it also introduced alternative and diversionary measures, which also help reducing caseloads and prison populations. Community participation in justice administration is a very important aspect and used to be an integral part of Thai culture and traditions. Many conflicts were resolved with mutual consent and satisfaction of the adversaries within the communities by respectable persons in that communities, mostly the elders, village leaders, etc. Through the community bonding and network, the duties of crime prevention, treatment, and support of offenders had largely remained within the community. Therefore, it is important to ensure the role of the communities in the design and implementation of the non-custodial measure and sanction. Next, I would like to highlight the importance of the use of non-custodial alternative on women offenders who are vulnerable groups in the criminal justice system. Even though women share a small portion of approximately 7% of the global prison population, statistics show that there has been a 50% rise in women's prison population since 2000 worldwide. The change in the composition of the prison population in the past decades has highlighted the shortcomings in almost all prison systems in meeting the gender-specific needs of women prisoners. Most women are charged with or convicted of non-violent minor offenses relating to poverty and familial roles. In Thailand, women prisoners make up 12% of prison population, and we have the highest female prison population in the Southeast Asian region. Over 80% of them are in prison due to drug-related offense, followed by property crimes. Only a small portion of women are convicted of violent crime. Statistics show that a large majority of women around the world are mothers and primary givers of children. This includes 87% of women prisoners in Brazil, 80% in the United States, and 82% in Thailand. Thus, the impact of imprisonment is far beyond on the women themselves, but also their children and family. Next slide, please. To supplement the principle of the Tokyo rules, the Bangkok rules put great emphasis on gender aspect of the use of non-custodial measures. The Bangkok rules call for gender-sensitive non-custodial measures, in particular Rule 57 to 62, recognizing the history of victimization of women offenders and their caretaking responsibilities, including the harmful impact of imprisonment on children. In particular, we need to look at how non-custodial measures can be implemented in a gender-sensitive manner at every stage in the justice process, from the pre-trial and trial stage to the sentencing stage and post-sentencing phase. Next slide, please. In this regard, UNODC, together with TIJ, has developed a toolkit on gender-responsive non-custodial measures. This technical toolkit aims to provide the guidance on how to apply gender-sensitive non-custodial measures for women in conflict with the law. It has built on existing international instruments, resources, and good practices globally to provide guidance for judges, prosecutors, and other criminal justice professionals in the gender-sensitive application of criminal procedure. Ladies and gentlemen, in conclusion, 2021 marked the 31st anniversary of the Tokyo Rules and the 11th anniversary of the Bangkok Rules, which both set out the need and application of non-custodial alternatives to imprisonment. This year has been an unprecedented year and has tested the resilience of criminal justice system. The pandemic has highlighted the harm of over-criminalization and prison future. As we looking to the future of prison system, it has become clear that prisons are overused and often don't serve the purpose of rehabilitation. We need to reform the criminal justice system and invest in non-custodial measures as a way of making it more just, rehabilitative, and equitable. Adopting this reformative approach cannot be done in isolation. It will require greater multi-stakeholder engagement and building partnership across sector. Lastly, I hope that through the opportunity to exchange views and practical experience, we are one step closer to making sure that non-custodial measures are not considered only alternative to imprisonment, but the primary mechanism for developing an effective and fair criminal justice system. Thank you very much.